Okay. So let's start with the next panel. Thank you for still being there with us at 4 o'clock Friday afternoon. And we'll try to keep you interested for the following hour. So we are delighted, Francesca, Raimondo, and myself, Christine Flamand, to welcome you to this panel on intersectionality. Please let me present the members of our panel. We have 3 members of the panel, experts on refugee law and migration, so we're very happy to welcome them. First, we have, I will start from Ellen at the end. Ellen Desmet is an associate professor at the Faculty of Law and Criminology at Ghent University, where she founded the Migration Law Research Group. She's also a member of the Center for the Social Study of Migration and Refugees in Ghent. And her research is situated at the intersection of human rights, migration law, and legal anthropology. So thank you for being here. Then we have Sibylle. I will start with Sibylle first, who is here. Sibylle is a lawyer, a human rights lawyer and migration lawyer. She's working at the bar of Liège, and she's also vice president of the Human Rights League in Belgium. Sorry. And then we have Julie Lejeune, in the middle. Julie Lejeune is working at Nansen. She's the director of this NGO, which is an expertise center on international protection. She's also vice president of the Federal Belgian Institute for the Protection and Promotion on Human Rights. And most of all, she is member of the advisory board of the VULNER project. So this is very important. So we are very glad to have you, the 3 of you here, and thanks for sharing your expertise after our presentation. So we'll start with our presentation, and let me introduce you to the situation of 2 asylum seekers met in the fieldwork in Italy and Belgium. We will start with Eduardo. Eduardo is an asylum seeker who comes from El Salvador, and he was escaping security issues in his country of origin. He came to Belgium with his wife and 2 children and asked for international protection. He stayed in the reception center somewhere in Bologna, and they were assigned a room for their family. So a couple with 2 adolescent children. There were several issues because he had health issues, diabetes, which obliged him to take insulin 5 times a day. At first in the room, he could access insulin because there was a fridge in his room, but later on, this fridge was removed to another place to get a new common kitchen in the center. So this fridge was removed, and he couldn't access that easily his insulin. He had to take a whole way back down to get his medication. So this was a little bit problematic. The other thing is that his asylum procedure was in Dutch, so he couldn't really follow the track of his procedure. Moreover, he was highly qualified, and he wanted his diploma to be recognized in Belgium, but he didn't succeed in doing so, and he ended up in working as a cleaning man. The second situation is one of Moussa. Moussa is from Burkina Faso. He left his country of origin because he was condemned for apostasy. He left Burkina Faso and went through Libya. In Libya, he faced violence, and he was arrested and kept in a detention center where he developed mental health issues. When he finally arrived in Italy, a few months later, he landed in an open center, but it was a CAS center that was overcrowded, and so his mental health issues increased. So that was a bit traumatizing for him. After medical exams and several meetings, he got medication, and at the end, his situation is stabilized, but he still has to take medication, and he has difficulties to access a job. We have Other examples that you can find in the discussion papers who are also very parlant, like we say in French, obvious. But these examples help us to understand that vulnerabilities can arise in the country of origin while fleeing the country for certain circumstances, also on the migration route when fleeing the country, and on the way to the host country, and finally in the host country due to the reception context or the asylum process. And of course, this depends also of their age, their health situation, their gender, their educational background, and other individual circumstances. In the case of Eduardo, the response of the reception center was inadequate regarding his health issue. Moreover, he felt dispossessed of his asylum process. It took him 2 years to get an answer, and he lived for 2 years in this little room with his children, where it was difficult for his bigger children, they were 14, 15, to develop a private life independently of their parents. Moreover, the procedure was in Dutch, as I said, and he felt a bit dispossessed of his asylum procedure, and also he found it difficult to access all the necessary information for his asylum process. For Moussa, the health-related issues were clearly amplified by the fact that he stayed in this crowded reception center. There was it was like a reactivation of former mental health issues. So it constituted an additional factor concurring to produce vulnerability. In this context, the reception is also inadequate. Even if he could access medical treatment, there was still a problem with the fact that he had to stay in this overcrowded center and wasn't transferred to a more individual reception process. So added to the experience of migration, a combination of factors might further impact the vulnerability as a continuum. The example we gave are examples of reception being structural factors that intersect with previous vulnerabilities. We observed in our research that there are different layers of vulnerabilities. Vulnerability is therefore not a fixed status interpreted from the perspective of presence or absence. So we think that the lens of intersectionality is core in order to have a better understanding of the vulnerability of the person. And they can reveal additional vulnerabilities. So Francesca will tell us more about this principle of intersectionality.
Thank you very much, Christine. So the above-mentioned examples, Eduardo and Moussa, show how different types of vulnerabilities might overlap over time. They could be personal vulnerabilities, so connected to all the personal factors or characteristics such as minority, sexual orientation, health issues, that lead the asylum seekers to experience fragility or to manifest specific needs. They also could be situational, so connected to a situation or to a present or past experience that make the asylum seeker more vulnerable. For example, migratory road, torture, sexual abuse, and trafficking. Lastly, they could also be of an administrative nature, so connected to all the legal and administrative conditions that protection seekers experience while awaiting the decision concerning the asylum application. Therefore, based on this scenario, an intersectional approach to vulnerabilities seems necessary, not only to have a better prism to identify them, but also to assess, and most importantly, to address them. Intersectionality has its root in anti-discrimination law and was first used by the African-American legal scholar Kimberly Crenshaw to describe the different type of discrimination suffered by Black women. By using the image of the road junction, Crenshaw described the situation of Black women who, being at the crossroad, at the intersection, indeed, of multiple social categories which might be discriminated, in this case, race and gender, they become victims of a new type of discrimination, which is qualitatively different from the one faced by white women or Black men. Applied to vulnerability, an intersectional approach becomes so an analytical tool to properly read the reality lived by asylum seeker and to examine the qualitatively different situation experienced by them due to the simultaneous interaction between several vulnerabilities, like we have seen in the stories of Eduardo and Moussa. Therefore, intersectionality aims to move from a categorical approach to a more holistic one, when identifying, assessing, and addressing vulnerability. But how doing it? In the VULNER fieldwork, it has been found that it is left entirely to the discretion of the individual judge or asylum officer, their good intention, time, and knowledge, whether they choose to integrate or not an intersectional perspective into their practice. So, what is necessary to implement, indeed, is an objective and comprehensive assessment of vulnerabilities from an intersectional scenario. In order to do so, it appears essential to introduce a multidisciplinary approach during the asylum procedure. Indeed, legal expertise need to be combined with others from other sectors, such as medicine, cultural mediation, psychology, and so on. And we are going to hear more in the discussion, I'm sure about that. On the other hand, it is essential also to increase the financial support, but most importantly, the training and the continuous education for the staff involved in the reception and decision-making institution to raise awareness about intersecting vulnerabilities. I will leave now the floor to our discussant and Christine to introduce them. Thank you very much.
Okay, the floor to Sibylle, Gioe, to react.
Good afternoon, everyone. Thank you very much, Francesca and Christine, for this work. And it interested me a lot. I was working on a case, and I will tell you the story of this case and how it is an intersection with what we have learned today about it. This case is a young man coming from a country where homosexuality is criminalized. He left his country and arriving in Belgium, he stayed in the streets for about 1 month, then was caught by the police and put in a detention center. He had to present his asylum claim from the detention center, and there was many factors that contributed to make it impossible for him to explain the ground of his asylum claim. To be specific, the asylum will be assessed on his credibility. And the credibility on an asylum claim grounded on homosexuality is also assessed with the spontaneity that people are capable of in their telling of their story. Spontaneity is a very specific way to tell a story, and all the vulnerabilities of my clients made it impossible for him to be spontaneous enough to fulfill the requirement or the expectation of the officers and the judge to convince them that he was homosexual. These vulnerabilities were administrative ones, situational ones, and personal ones. First spot that I would like to point out, it's his homosexual coming from a country where homosexuality is criminalized. Therefore, it was very difficult for him to speak about what is homosexuality, how he feels about his identity. He never did that before having to do so in front of the asylum body. So this is the first interaction between a personal vulnerability and a situational vulnerability. Second, he was living in the streets for 1 month. So when he was put in the detention, he was tired, exhausted from the living outside and trying to fight for his survival. And also the street, spoiler alert, is not a safe space where you can freely open up about your sexual orientation. Therefore, he had never spoken about his sexual orientation before having to do so before the asylum bodies. So this is also a situational vulnerability that interacts with the personal and other situational vulnerability. Then, the big elephant in the room, being in detention. It's an additional vulnerability that increased the level of vulnerability of my clients. It's an administrative and situational vulnerability. Why? Because being in detention means many things. First of all, it's not either a safe space. You have inmates and you cannot fully open or try to talk a little bit about your story because there is a great risk of being persecuted in the center and you cannot escape from a detention center. So there is no way he could be protected if he opened up a little bit about his sexuality. Therefore, impossibility to talk about his homosexuality before having to do so in front of the asylum bodies. Also, in detention, and it's also an administrative vulnerability that increases again the level of vulnerability, in detention you have an accelerated procedure, which means that he has only a few days to prepare his interview of first instance of asylum. A few days is totally insufficient, for example, to meet special LGBT network support that will help him to discuss about it, to find out how to explain very intimate things before strangers. And this was then it was increasing the level because he had no support except for a lawyer he met a few days before. That's me, I arrived just a few days before his interview, and in a few days it was absolutely impossible to address all the needs he showed to me at that time. Because he was persecuted in his country, he had a PTSD, but this PTSD, there is many interaction between all these vulnerabilities. The PTSD increased because he was isolated in the detention center, he had no social contacts because he was in fear, because it's not a safe space, because there is homophobia, potentially homophobia from the inmates. So the increasing of the PTSD didn't help him that much either before the asylum body. And then there was another thing that I pointed out. Yes, something that it's ought to put it like it's a vulnerability, and this is a point that maybe I would like to try to make. It's that sometimes features that individuals have doesn't seem to be factors of vulnerability, but in a specific situation, in a specific context, they become a factor of vulnerability. In that case, it was that this young man was well educated and was just finishing university, and because there was no resources at all, there was no LGBT association to support him, there was no psychologist in the detention center in the short amount of time. I had only a few days to help him to prepare, and I had to do some stuff by phone, but it was impossible for him to say other things that yes and no, because there was individuals around him, so very complicated. So he used the resources he has, his background in university, and so he responded to the officer of protection like he was in an oral exam. If you remember correctly your oral exam when you were at university, these are not the best time of spontaneity you have ever experienced in your life. I would say probably the worst, even though your answers were accurate, correct, that you say the truth, and so on. So this was a disaster. The officer and the judge, when I read the decision and the judgment, had no holistic approach at all. About the administrative factors, so mainly the fact that he's in accelerated procedure and that he's in detention center, there is a big denial. It's not vulnerabilities, it doesn't exist. Indeed, the accelerated procedures have been told by the Constitutional Court as effective remedies, and there is no problem with accelerated procedures. So it's not taken into account as a factor of vulnerability. For the detention, it's very normalized for asylum seekers, even though it's not very respectful of human rights, but it's very normalized, and so the judge didn't take into account the detention factor as increasing the vulnerability. About the situational factors, the background from a country where homosexuality is criminalized and therefore you are not used to talk about it openly in front of strangers. like it's symbolically taken into account. Like, yes, it's hard, however, and, and the rest of the decision. So it's not really taken into account and not really in interaction with all the other factors. And about the personal vulnerabilities, there was an insufficient approach or a misunderstanding approach. Like his diploma was seen like a factor of empowerment and that he should be able to speak in a better way, more openly because he's well educated, and in his case it was more a factor of adding distress to the interview. Just a point about the law. During the procedures, during the asylum procedures, the state should take into account the special needs of vulnerable people. But the problem is that the law in Belgium puts the burden of the proof of the special needs and the vulnerability on the shoulder of the vulnerable people. So for my client who lived in the street in 1 month, is put in detention, has to get to an interview in a few days later, has no time to see a psychologist, no possibility to make a psychologist come in the center, no LGBT group support, nothing at all. It was impossible for him to enumerate, to explain, and to anticipate that it would be a disaster. And this is problematic because in the EU law, it should be the state that assess the vulnerability and take care of finding how it will be an interview that take into account procedures that is respectful of the vulnerabilities and make the people at ease to speak about very delicate matters. Because I was asked to talk about my experience as a lawyer, I was not able to provide all the support my clients needed in such a short time. So it's very frustrating because I can do whatever I can. I'm just one person, and when the recommendation is that there is a need for a multidisciplinary accompaniment, I couldn't agree more. As a matter of fact, I tried to set a meeting with a psychologist, but because the PTSD in itself wasn't serious enough, it wasn't possible to provide a free psychologist to come into the center. Actually, the PTSD is in interaction with all the factors of vulnerabilities a problem for him to express, but in itself, it's not serious enough, and so this is why the intersectional concept is very useful in that kind of cases. I tried to ask for LGBT support group to come in the detention center, I called them, and explained that there was not sufficient resources. So I couldn't agree more with the previous recommendation that says, please finance the NGOs that are helping on the ground. So even, and also I had only 10 days to make appeal, but this is kind of crazy because in that kind of days, it's impossible for me to get all this support again. So in the end, not taking into account the combination of the vulnerabilities, but to take some of them in isolation and ignoring some of them was conducting here to a almost kind of death sentence, because in the end, the decision is that he has to go back in a country where he will probably die or be detained. So I would say that this paper will probably help me a lot in that kind of case, and so thank you very much for the paper and your recommendation. Thank you for your attention.
Thank you, Sibylle, for giving this very concrete example of why intersectionality is important. Julie, it's your turn now. Thank you very much.
Always tricky to take the floor after a good lawyer, no? You've been there, I guess. However, it's a real pleasure to be here today and to get a chance to share with you some of the insights from the ground, Belgium again. So this is a Belgian panel. You should be aware of it. And I will tell you in a few words where I speak from today and make then 3 comments relating to the findings of your paper, and also to what Sibylle put forward a moment ago. In Belgium, Nansen is a unique actor dedicated to the quality of the international protection procedure, supporting the different actors of this procedure and developing an interdisciplinary approach of asylum. So our daily activities puts us actually in contact with individual asylum seekers, their lawyers, the social assistants, the social workers, the asylum authorities, and also several dedicated expertise centers of academic expertise, on international protection related issues. So my first comment is on the statement from your policy brief paper that an intersectional approach is needed when dealing with the vulnerabilities of as individual asylum seekers. And I just want to share that from the last 5 years of activity of our NGO, multiple vulnerability factors on top of being an asylum seeker are represented in an average of 1/3 to sometimes close to 1/2 of our 150 cases annually. So we obviously encounter, and Sibylle mentioned some of them, a very wide array of these factors, including sexual orientation and gender identity, but also the situation of single parents, for instance, or those who are struggling with mental or physical health issues, among which also survivors of torture and of gender-based violence. And the individual with support, they are mostly involved in multiple asylum application. So a quick caveat here, just to say that we are very much aware that the findings we make, we do that on the basis of a relatively small amount of cases. And mostly we draw our analysis from the reflection and the lecture on the negative decision in the asylum procedure because they are motivated. But still, we are confident that the findings are valid and at least representative. If it's not exhaustive description of, it's a representative of the obstacles faced by the migrants and the asylum seekers in particular in accessing international protection. So the figures that I just gave confirm actually one of our structural findings, which is a relatively global failure of the asylum system to properly and efficiently detect vulnerabilities and to give them a proper consideration. So I mean here, to allow for the detection of a vulnerability to really change something, have an impact on the next steps of the procedure. And I will not expand on this now, but I believe it's worth a thought on the issue of multiple asylum application in the context of the discussion on the vulnerabilities and possible overload of the system. Now, our finding on the global systemic failure of the system, the asylum system, we documented it in particular by 4 years of close monitoring of asylum seekers in detention centers. And it is still valid today. I think you made that point as well. It is also concurred by the observation of our partners in the field. And I think that today more than ever, we all really need to be vigilant about the working and the features of the asylum system at the borders, on their efficiency in, like, open the brackets, screen the vulnerabilities, close the brackets. So at this stage, I just want to suggest that indeed, as you put it, the intersectional approach of vulnerability, by intertwining the silo of the categories established by the vulnerability approach, might fix some of its excluding potential. But there is a but, and this brings me to the second comment. As Francesca read it aloud, and she put it forward, it is left entirely in the Belgian system to the discretion of the individual judge or asylum officer, their good intention, time, and knowledge, whether to choose to integrate or not an intersectional perspective into their practice. And I would like to bridge this statement with our findings that the asylum system is not only too often failing to properly detect situation of vulnerability, but also failing when such a situation is identified and detected in keeping this flag raised for the various actors over the various steps of the procedure. So what we see is that there is little to no internal systemic consistency in the taking into account of the vulnerability, and this echoes the demonstration made by Professor Hathaway yesterday evening. So a few examples. For instance, our national authority assessing the need for international protection in first instance has recently officially confirmed that in assessing the existence of specific procedural needs, they are not bound by the vulnerability flag raised by the Immigration Office at the stage of registration of the asylum claim. On the other hand, in some case of multiple application, then we have observed that the decision taken on the existence or not of the procedural needs seems to be taken once and for all at some point and not reconsidered later. But again, in other cases, what we have come across is that cases were recognized, the individuals were recognized having specific procedural needs only in a third asylum application on a total of 5. Of course, yes, in the third asylum application when the hearing was disrupted by a severe hallucination episode of the asylum applicant. But then this specific procedural need was not recognized in the 2 subsequent asylum applications, even though there was a psychiatric and a psychological support ongoing and a profusion of medical documents. So probably the only compensation for this lack of internal systemic consistency comes from the role played by individuals, from the social workers, and that was discussed yesterday afternoon. But most certainly individual lawyers, and we heard from Sibylle, and also including individual judges and individual asylum officers in the decision-making process. So maybe just a comment on this, that probably we might be grateful for a system that allows this margin, this space for individuals to implement their good intentions and their lucidity or their approach of the vulnerable situation they are facing. And maybe even we should cherish the features of the system, allowing the actors of the procedure to do so. And I'm thinking of the in-person hearings for the purpose of determining the need for protection. But I would also say that the case-by-case difference made by individual is really a too weak compensation for the systemic failure, and we could expect the system as a whole to be much more efficient to this regard. And this brings me to my final comments relating to the third statement from your policy brief on the fact that the asylum process fails to draw from the expertise of other disciplines. And here, I would rely on our 3 years of monitoring the position of victims of torture in the asylum procedure. So, there is a series of ad hoc refugee law principles guiding the handling of asylum applicants who have been victims of torture, right? Here is a group of individuals who often provide for medical legal reports in support of their claim for international protection. And one could expect that in dealing with this situation, the asylum system, the process, is able to draw from the expertise of medicine and or psychology. Also in particular, because there are international standards available here guiding the non-legal experts in drafting medical legal reports for the very purpose of the asylum procedure. That is the manual on the effective investigation and documentation of torture and other cruel, inhuman, or degrading treatment, also called the Istanbul Protocol. So we have monitored through the analysis of case law, both French and Dutch speaking in Belgium, the consideration given by the asylum instances to the medical legal reports established conform the Istanbul Protocol. And in a nutshell, our analysis shows that the asylum authorities really struggle to decide to which extent they should trust any medico-legal report. Our finding is that the existing tools are insufficiently used. Firstly, the Article 18 of the Procedure Directive, which is allowing an assessment of vulnerability by means of a medical examination, is actually transposed in Belgian law, but has never been implemented. This has been confirmed officially by the instances no later than September 2022. And second, there seems to be a real lack of awareness and understanding of the framework provided by the Istanbul Protocol. In particular, we see a tendency to be more reluctant towards medico-legal reports that have been established by general practitioners and more confident towards medico-legal reports established by specialists, when actually the most recent version of the Istanbul Protocol, dating from June 22, includes a paragraph 303 clarifying that, and I quote, "Conducting evaluations in accordance with the Istanbul Protocol does not require certification as a forensic expert, even though this may be the normative practice in some states and is sometimes used to intentionally exclude the testimony of independent clinicians from court proceedings." So, in a conclusion, I just would like to suggest that or multidisciplinarity, and we could discuss the terms, might go hand in hand with the concept of intersectionality, but that it brings own challenges to the fore because it does take two to tango, you know, and in Belgium, at least, the asylum authorities are still trying to find their feet in accommodating the reception of expertise from other disciplines. Voilà, so far for my contribution. Thank you.
Thank you very much, Julie.
Okay. Good afternoon to all of you. Thank you for the invitation for this panel. And I would like to start with congratulating the whole VULNER team with their excellent work. You have produced an impressive amount of high-quality research papers and research reports and policy papers, providing a nuanced and contextualized understanding of this very messy and multi-layered concept of vulnerability, and also demonstrating the relevance of combining legal and anthropological research methods and concepts. So congratulations to everybody of the VULNER team and Luc. My reflections will be from a more academic perspective and a bit more reflexive maybe, and that's what we academics are paid to do, on this call to adopt an intersectional approach to assessing vulnerability. And I will cluster my reflections around 4 topics or keywords. One, TIC intersectionalities, then intersectional reflexivity, 3, modesty, knowledge modesty, and finally, operationalization. First, TIC intersectionalities. In the first research report on Belgium, the researchers state the applicant's profile as a whole, including their life stories as well as their background and experiences, even if not strictly connected to the asylum application, should be considered to adequately assess and address their vulnerabilities. So rephrasing a bit this call here for an intersectional approach to vulnerability. And I think we can translate that in a way to this concept of TIC intersectionalities, which was used, for instance, by Professor Goustiep, who is a professor in communication studies, which I'm not an expert in, but I think it's a relevant field to look at because every encounter between an asylum seeker, a person seeking protection, and somebody in the host country, be it a judge, a protection officer, a lawyer, a social worker, is by definition an intercultural act of communication. And this concept of TIC intersectionalities was developed as a bit of a critique to what has been called the race, class, gender, sexuality mantra, which produces a bit of a roster-like, kind of more superficial approach to intersectionality. by listing certain categories as components of one's identity. I'm a white, middle-class, academic, and mother. You may have an asylum seeker who is then categorized as black, lesbian, able-bodied, and so on. But we have the risk there that we tend to homogenize people inhabiting similar intersections, leading to the assumption that all black lesbian women will have the same experiences or demonstrate the same vulnerabilities. And so I think what you suggest of taking into account the whole background and experiences and so on relates to this concept of thick intersectionalities, suggesting an alternative approach, accounting for the lived accounts and embodied specificities of persons. A second topic, or 2 words, intersectional reflexivity. I had the honor of being recently in a panel with Behroj Bouchani, the Kurdish-Iranian writer of No Friend But the Mountains, who was held for a long time on Manus Island. And when he was asked, okay, what are the do and don'ts if you meet a refugee in detention, the first thing that he said was be aware of the power imbalance, and the imbalanced power relations between a refugee, especially if you're in detention, and a person, a volunteer, for instance, visiting a detention center, but also any other person. And this brings me to this issue of intersectional reflexivity, because what risks maybe being a little bit underexposed is that the assessment of vulnerabilities, it's not done in the air, in a vacuum, by disembodied machines. It's human beings who are assessing the vulnerabilities or trying to accommodate the vulnerabilities of other human beings and of applications for international protection more broadly. And we all also have our own intersection identities, our own age, gender identity, sexual orientation, specific life experiences that may consciously or unconsciously also interact with how we assess vulnerabilities and so on. And also in research and social science research especially, it's increasingly common to reflect also on this positionality as a researcher. And I think linking to that, it's also important to be aware of this intersectional reflexivity in the terms of Jones being aware and reflective of our own intersecting identities, and that we also acknowledge the disadvantages and privileges that come with them. And not to say that everything is relative and so on, but being reflexive of these own intersectional identities might also facilitate identifying certain biases or stereotypes in our own reasoning. For instance, we read in the VULNER report that single men are per definition not seen as vulnerable, which is a kind of stereotype of assumption that we have created in our Western society, maybe linked to the wild male privilege, whatever. But being more reflexive of our own intersectional identities might prevent this, especially in an intercultural communication that is also very much shaped by these power relationships that Bouchani also mentions. A third concept or call is modesty, humility, because I think the concept of intersectionality illuminates the complexity and the immense complexity of the human experience. The VULNER project has shown how these vulnerabilities overlap, are complex, evolve, and so on. And so realizing this holistic assessment of intersectional vulnerabilities, it's really, we have also heard it from Sibylle and Julie, it's a daunting, it's an overwhelming task, especially for one individual. And we need these insights from other disciplines, as Julie mentioned. We need insights from medicine, psychology, linguistics, gender studies, and so on. And there's an explosion of knowledge in all these disciplines. So you can conclude it's virtually impossible for one person or even a multidisciplinary team to have all these knowledges and skills that you would really need in an ideal world to assess an application for international protection with the greatest possible scientific accuracy to the extent that that is possible. And this way, the VULNER project recommends to relieve individual decision makers of this burden of having to implement this holistic approach by establishing a multidisciplinary approach, which we need, by engaging experts from different disciplinary backgrounds, providing training to the authorities. And I fully agree that we should walk this road as far and as good as possible. But on the other hand, we should also be realistic, probably, in the sense that we're living in a world of scarce economic resources, which turn out to be even more limited when it concerns asylum persons. So this will not be realized tomorrow, that every application for international protection will be assessed by a multidisciplinary panel with all the possible expertises of all the intersecting vulnerabilities. So where does that leave us? What to do with this realization that our knowledge is partial, limited, fragmented, even though these concepts of intersectionality and interdisciplinarity in a way help us to get a glimpse of this iceberg of reality that is laying there beyond the water. And in this sense, I think we should be modest about our knowledge, and I think this realization of knowledge modesty and the possibilities that we have has as a consequence, in my view, that we need to be more careful in our assumptions and our findings, our assessments of asylum claims, and see it as both an ethical and a scientific imperative to adopt a more precautionary approach, apply the benefit of the doubt in a more lenient manner, at least until we are collectively more established in engaging with these intersectional vulnerabilities, and probably, and also beyond that. And so summing up this third issue, the fact that we need so much knowledge from different disciplines to be able to adequately assess vulnerabilities and specific asylum claims in general should probably instill an attitude of modesty, humility, restraint, prudency in assessing vulnerabilities and applications. Because as we heard, errors come at a high price in asylum law. Finally, operationalization. How do we make these policy recommendations more concrete? Because in a way, as academics, our job is done. Policy recommendations are even going beyond the research findings, so you already made a step towards policy recommendations. But if in order to really contribute to social change, it's probably needed to engage in a collaborative endeavor with protection seekers, practitioners, civil society organizations, and policymakers to really try to apply and translate these research findings in daily policies and practices. And so even though this is the end of the VULNER project, I hope it's not really the end, but it's a line of research and the collective efforts to realize these policy recommendations, that they may continue. Thank you.
Thank you, Ellen. I would like to say it in French, remettre l'église au milieu du village. Put the church in the middle of the village. So we are talking about precaution, holistic approach, benefit of the doubt, getting back to very important principles, but taking into account the full profile of the person and doing it the best we can with an objective and consistent approach. Francesca, would you like to add something before giving the floor? Well, okay. Who would like to ask questions about, react about those interventions?
Thank you. Just a very short one. How to convince the authorities that it's a necessity, that it's not so costful, that they will not the fact that to take into consideration in a consistent way this vulnerability, but with all those dimensions, how to convince that it's not too difficult and too expensive, and maybe that they could earn time. They could gain time while examining the application and the application to get a protection in a right way.
Would somebody want to react? I would just maybe say from our point of view, I think Francesca agrees with that. If we could just take into account the certificates that are, when psychologists or doctors give their expertise, why would this expertise always be brought in doubt? I mean, it's always something that often it's not taken into account, unless it is a psycho-medical legal report in the sense of the Istanbul Protocol. But when it's a simple medical certificate, there's always a doubt about the essence of it. And this is, like you say, Sylvie, this is time-consuming, because if they don't take it into account, we will need maybe another expertise, or there will be rejection. So I think if already the asylum instances could just take into account what the doctors, the medical experts, psychologists and others tell the judge or the asylum body about this person, about what she has been going through, this will already be a lot of time gained. Is somebody else?
Thank you. If I had a magic wand, I would love to see some different statistics than the one that we always get served on a plate, you know, and to have longitudinal trajectories of applicants and understand better how many of them have to apply several times to, in the end, get a protection, right? And taking into account the corrections of the first asylum instances decision made by the courts, and then all the system. We always get figures on the very first short stage of registration and first applicants' success in asylum, and then sometimes figures without the multiple applications, to say that without the multiple applications, the protection rates would be higher. So we lack knowledge on the efficiency of giving access to international protection of the whole chain. There is not enough knowledge.
Maybe as a way not to overburden the asylum authorities themselves, it could be an option to, that if they would be more open to not only psychomedical reports, but also reports of other experts from an anthropological, linguistic perspective and so on, without having to do it themselves, but be open to the evidence that is provided, which can then be supported by NGOs and so on. That would be a way, that doesn't overburden them, maybe gives them the chance to get it right the first time, and save time by avoiding then subsequent applications.
Just to add something, actually, as we have seen, I think, in these 2 days, intersectionality is really the rule, not the exception, in when we take into account vulnerability of asylum seekers. And as I think, we have said in our policy brief and also today, the work of this panel actually was possible thanks also to the data that we received from the other team. And specifically the Italian team mentioned to us that actually many judges sometimes are taking into account these intersectionalities or the intersectional vulnerabilities. But the thing is that it's not done in a consistent way. And doing it in a consistent way maybe would improve actually the efficiency of the system, as already been said, and in order to avoid to arrive till the appeal, for example, and then recognize that there are other things to take into account. So maybe this could be time-wise, but also more efficient. That's it. Other question?
Thank you so much. No, it's true. It's better with the mic. Thank you, Peter, and thank you so much for the discussion on the panel. No, I just had one question that came to my mind by listening to you, and also to the testimonies we've heard from Sibylle, among others. I think we all agree, at least among us, if I can say, within the VULNER project, on the usefulness of mobilizing intersectionality and vulnerability when it comes to understanding the realities of people. My question was a bit more, what about the asylum process itself? Do we need to use intersectionality in connection with vulnerability? And I think you've showed in a very convincing way that it is useful and can have certain advantages, but does it necessarily needs to be the case? And when I was hearing Sibylle, I was wondering whether the intersectionality she was talking about was more an intersectionality in assessing a persecution risk, rather than an intersectional approach in assessing vulnerabilities. So in other terms, do we need this filter of vulnerabilities in all and every case? And do we need to use it when it comes to really assessing the risk of persecution, as is the case in the examples that were shown to us today? So that's really an open question that I have. Can we use intersectionality independently of vulnerability? That'd be a bit my question to you. Thank you.
Thank you. It's true that in the example I focus about the procedure and not about the grounds for asylum, and I had to make some choice between the cases I could present and that have a link between vulnerability and intersectionality. But of course there is other cases where for the qualification of the status of refugees, it can happen that there is, yes, with the social group, probably we meet the specific criteria that make narrower. Well, I can express myself correctly on that one. I take a break. So, like, for example, I will take a very obvious case, like a woman coming from a very patriarchal country. So she's a little, maybe not sufficiently at risk to fear persecution per se if she comes back just on the ground that she's a woman. But she's from an ethnic minority group, but just being from that minority group in that country is not sufficient enough to be persecuted per se, just coming back in the country. But being a woman from a minority group can then expose her more to persecution. So, of course, the vulnerability and the intersectionality concept can also be used in the qualification. But I'm not sure it was your question? Not really.
Yeah, and do you need vulnerability on top of it in that context?
Well, I would I don't know. Honestly, I don't want to say yes or no because I think it's more academic question than practical question. And so I dropped the mic on my left.
Do you want to take it? No. The only thing I was going to say is just that I would indeed say very naively dare to say no, based on a study made by François Crépeau, who shows that it is really key to the very nature of the refugee status determination to be faced with questions at the very crossroads of legal expertise with the whole set of concepts developed by the refugee law, psychomedical expertise, because we are speaking of a human encounter and of persons who receive a narrative of happenings, most of the time heavy ones, and we heard that yesterday, and vicarious stress and that concepts. And the third field, which is intertwining into the asylum procedure, is the intercultural that Ellen put forward also very clearly about two people meeting each other from various backgrounds, and also one having to assess a geopolitical situation abroad. And all these aspects are just key to the international protection procedure, and we don't need probably vulnerability on top of it all.
Because I'm thinking no, because creative time. Thank you. I was thinking about the possibility to seek for protection from the authority, and then it is asked to the asylum seeker to prove that it's impossible to get some protection from the state, and then the intersection and vulnerability concept can apply, because you can show that more the person is vulnerable, and so more vulnerabilities interact between each other, more it's difficult for that person to seek for protection from the authority. So I wouldn't throw the vulnerability concept immediately to the bin for the qualification status, but it's just thinking out loud. So.
Okay, thank you very much. I think we have to finish, or? Okay, sorry.
Look. Just adding a last word on this. So, Nora Markand is a legal scholar, it's a German legal scholar, talking about the Geneva Convention. She was saying actually that the belonging to a particular social group is a ground open to intersectional scenario. But I think that over these 3 years of research into VULNER project, we have learned that actually the factors of vulnerability are much more than one connected only to the groups, for example. And so I think that the vulnerability concept is still necessary in order to identify the other grounds of vulnerability, for example, connected to the life in the reception centers, or, for example, sometimes for education and socioeconomic background, so to read all the other nuances. So I agree with you that maybe it's something connected also with the grounds of persecution, but still, we still need the concept of vulnerability, I think. Thank you very much. And over to Christine.
Thank you, Francesca. So we keep vulnerability for assessing the asylum claim and the procedure and everything. And we thank you very much for your participation.